Hello and welcome to the program. I am DEJI360. So the much talked about Presidential Executive Order 10 has finally been voided by Nigeria's apex court. The Supreme Court declared the Executive Order 10, which allows the federal government to deduct from state government accounts monies meant for state judiciary and legislature now and pay same now directly to them. Now, the Supreme Court says that executive order is unlawful and unconstitutional. President Muhammadu Buhari had signed the order into law in May 2020 to guarantee financial autonomy for state legislature and judiciary. The president had said the order would strengthen the institutions at the state level and make them more independent and accountable in line with the tenets of democracy. This move was, however, rejected by the state governors who demanded the immediate dissolution of the Presidential Implementation Committee that was set up after that executive order. And of course, the governors challenged the executive order at the apex court and asked the court to compel the federal government to take up funding of capital projects and recurrent expenditure for state high courts, Sharia Court of Appeal, and Customary Court of Appeal. The governors argued that the three courts were courts of the federation, and as such, the funding of their capital projects should flow from the consolidated revenue fund of the federation. They also applied for an order of the apex court to compel the federal government to pay them 66 billion naira, being an amount, according to them, that they had spent on capital projects for the three courts. Now, ruling on the case on Friday, a majority of the court's seven-member panel agreed that the president exceeded his constitutional powers in issuing the Executive Order 10. The apex court, however, dismissed the 66 billion naira suit filed by the governors, meaning that the funding of state courts lies squarely with the states. Joining me to discuss the implication of the Supreme Court verdict on the autonomy for state judiciary and legislature now is legal practitioner Libros Oshoma. I also have public affairs analyst Nelson Ekujimi joining us on the program as well. Gentlemen, thank you very much for coming on the program. Libros, you are the lawyer here. Let me start with you. What exactly is the implication of this decision by the apex court?
Yeah, thank you very much. The implication of this decision is that executive order 10 that tends to spell out the implementation of section 121 subsection 3 of the 1999 constitution has been struck out by the Supreme Court. And so what that means is that that order had been rendered null and void. It's a nullity. So that order, as we speak today, no longer exists.
So could we also say part of the implication is that as it stands now, financial autonomy is, well, to some extent dead, unless, of course, maybe there's an amendment to the Constitution. Financial autonomy now for the judiciary and the legislature at the state level.
No. The section 121 subsection 3 already guarantees financial autonomy.
Yes, you're quite right. But the reason I ask this question, we know that section 121 subsection 3 guarantees that. But the truth is that nobody, I mean, the governors had not been complying with that section of the Constitution. And that's the reason why Executive Order 10 came up in the first place anyway.
No. That is not how you enforce provisions of the Constitution. No matter how good an executive order is, it cannot take the place of constitutionality.
Absolutely.
In a constitutional democracy. And so what should have happened ordinarily would be to spell out what should be done in the event that that order of the law is violated. It is the same law that empowers, that gives powers, that is the same law that should spell out what should happen in the event of violation. Because
in the case that was not spelled out as we have now, so what then happens?
If it is not spelled out, what you do, you go to court to ventilate your anger when it is violated. You cannot, because you might have a good executive order today, and if you allow it, tomorrow you can have a dictator, and all he would need to do is to use executive orders to override the provisions of the Constitution. I think that is what the Supreme Court was trying to protect.
All right, Nelson, let me get your take on this, because, I mean, essentially, we know why Executive Order 10 came about, why it came about. We know that before Executive Order 10 came about, even unions in the judiciary had embarked on a 45-day strike where they were demanding that states actually comply, state governments now comply with the provisions of the Constitution. And at the end of the day, Executive Order 10 came about, and then the whole strike was called off, the issue was resolved, and now we have this, of course, the Supreme Court ruling Executive Order 10 out of order, if you like, using legislative language now, but, you know, essentially declaring it void. So where does that leave us?
Well, well, once again, thank you very much. I want to absolutely align with my colleague, Liberal Soshoma, on the position that this is a victory for the rule of law, because we recognize that we practice a constitutional democracy. And like he has rightly said, no matter how good intent an executive order should be, one expects whoever is issuing that order or whoever is going to implement it, you know, to go through the instrumentality of the law. So one expects that, you know, even if the intention was very, very noble because of the excesses and the, you know, the misdemeanor from the state governments with regards to the financial autonomy for the states and the judiciary, states, you know, legislature and the judiciary, one expects that the rule of law should have been, you know, should have been followed. So going forward, I think it is now left for the legislature to do the needful now, that the courts, that the Apex Court has given this judgment, which is very logical, which is rational, which is in tune with the provisions of the Constitution, because you cannot substitute the provisions of the Constitution with the order of the president. It is not, you know, it is not applicable. A president will come and go, but the Constitution remains, and the Constitution is the Bible governing our conduct as human beings, as, you know, as institutions within the Federal Republic of Nigeria. So going forward now, based on that judgment, because you can see that even from the judgment, the 66 billion naira that was demanded by the 36 state governors as the amount that have expended for capital and recurrent expenditure since 2009, you know, the court denied, you know, that prayer. And that is to tell you clearly that the court also recognizes that, look, you also have not been up and doing with regards to your responsibility. That is why this order has come into place. So going forward is for the legislature to now wake up and do the needful to correct this anomaly that, you know,
When you say correct, you expect the National Assembly, for instance, to probably begin to see how they can amend the law and probably create a provision, so to speak, that maybe provides for what should happen.
Absolutely.
When state governors refuse to.
Absolutely. Just like Liberals has rightly said, you know, for the Constitution should stipulate penalties for erring states that refuses to comply, because the Constitution has also in sections 121 subsection 3 stated how the funds, you know, should be disbursed, and if anybody or any state government refuses to comply, the same section should be amended to allow for penalties, you know, that should follow. In that way, we'll be whipping any errant governor that wants to, you know, undermine our Constitution into line constitutionally.
Liberals, don't you think these governors are actually taking advantage of, you know, some of the, I don't want to use the word defects now, but some of the shortcomings in the Constitution, especially with regards to section 121 subsection 3 now, because it actually makes no provision for what happens now if they fail to comply, that they are taking advantage of this to commit impunity, because for like ages now, governors have essentially refused to comply with the provision of financial autonomy, not just for even the judiciary and the legislature, but also for local governments as well.
DEJI, there are no perfect law in any society. Everybody, every politician, the duty of politicians really, while thinking of how to win the next election, is how to circumvent the law. And that is why, in most cases, in every society, it is the people that demand obedience to the rule of law. The politicians will always want to circumvent the process. So the governors would want to bypass processes and cut corners And just imagine, in one breath, the governors are arguing that you cannot give autonomy to the courts. But in another breath, they are saying that these courts should belong to the state high court, should belong to the federal government. The capital project for the state high court should be, the responsibility of those projects should be for the federal government. And so it's like blowing hot and cold from the same mouth. And so what the Supreme Court has said, the Supreme Court has identified the fact that these courts are state-owned, but that to enforce autonomy for this court, you do not need an executive order, but an amendment to the Constitution. That it is ultraviolate the powers of the president, as spelled out in Section 5 of the Constitution. But also, the people involved, I would agree that the courts can go, the judiciary can go to court. But you have the bar, the NBA, also practice with the bench. One would have expected that this would be a matter for the MBO to take up at, both the apex court to compel state governors to obey the autonomy for the judiciary. And one would also have expected that the state houses of assembly should also approach the Supreme Court on this issue. But you find situations where the state house of assembly are almost acting as an appendage of a sitting governor. You remember in the Second Republic, you hear that even members of the House of Assembly will take the speakers to court or a sitting governor and in enforcement of the provisions of the law. But today, you hardly hear of such. You hardly, except when it matters, when it is matters that borders on a ticket or no ticket, candidature or no candidature. So in this case, one would have expected you have what you call a conference of speakers of state house of assembly. One would have expected that these people would come together and address this point to ensure that there is autonomy for the House of Assembly so that they will no longer act as an appendage to the executive. Look at what is happening in my state, Edo State, for example, where the governor acts as an emperor and he has, how do I put it now? Pocketed the State House of Assembly. It's almost non-existent. In clear violations of the Constitution and also in collaboration with the State High Court. Because the matter that was filed at the State High Court had passed through 9 judges, and yet that matter had not been heard for 1 day. So it is the rest of us, Nigerians, who are also public interest savvy, and then the NBA especially, and then some people who also aspiring to be members of the House of Assembly to take up this matter, and then let's all go and sit down in the houses of our national legislatures to ensure that there is, a proviso or a provision in the Constitution spelling out, penalties for defiance or disobedience of Section 121, Sub 3. DEJI, if you remember quickly, so I yield the floor for my colleague. Recently, there was a fight between the National Assembly members and their governors on direct or indirect primaries. Yes. It became so strong that, that had cost us consistently the signing of the Electoral Act, because it's a matter that affects their re-election. It is not a matter that will be beneficial to all Nigerians. And so, in rounding up on your question, definitely governors would want to circumvent process and take advantage. But we need independent courts to be able to activate instrumentalities of the law and also create a dichotomy between the office of the Attorney General and the Minister or Commissioner for Justice. Yes. So that they'll be able to take up matters like this immediately and approach the court and ensure that the provisions of the law is complied with.
Nelson, do you think that lawmakers at the state level have the political will, for instance, to go to court to challenge the abuse of the provision of that section of the Constitution? And how quickly do you think, for instance, the National Assembly can amend the law to guarantee? Because whether we like it or not, look, this is something desirable. This is something that should be. The abuse has to be stopped somehow.
Yes, starting with the last question, we all know that the process of amending our constitution is very, very cumbersome, and in this case, knowing the enormous influence the governors wield in our political dispensation, it's not a bad idea if we try, but we all know very well that it will take a very, very long period of time. But the time it lagged or time frame notwithstanding, it is not too late in the day if we start that process and see where it will lead us. Then talking about the states' houses of assembly members, whether they have the political will. Absolutely, because one has had the opportunity of interacting with quite a number of them, and you meet some of them and you recognize that these are highly intelligent, highly dynamic, highly sophisticated members of the House of Assembly who know their onions. But you and I know that in politics, like we always say, 2 plus 2 does not add up to 4. There are so many interests that is at stake. And I think I've told you some time ago on this platform that, even as a legislator, when taking decisions on behalf of your constituency, it's very, very important for you to be conscious of the fact that, of the Yoruba saying that says, when they say, Majolo Mungwe, meaning continue to dance and behind you, you need to be, very, very careful so that you are not seen as somebody who is going to rock the boat. But in as much as this is a dilemma facing the Nigerian people, this is a catastrophe that is lying in wait. It behoves on us at the level of the civil society. I'm talking of the general
as Nigerians,
as Nigerians, general populace,
to mount pressure
for us to continuously mount pressure. Like when you
especially on the National Assembly.
Absolutely. When you called me for this program this afternoon, part of the discussion we had before we came on set is that this is a matter that we must put on the front burner because it is about what affects the lives of every Nigerian. People should not see it as a matter between the judiciary, the courts, and the governors. No, absolutely not. Because you recognize that sometime last year or thereabout, the judicial workers went on strike for almost 45 or more days. And you can imagine the colossal damage it did to our psychology. If an arm of government, when we are not in a military rule, is suspended, because that in a way could be termed a coup of sorts. Because under a military dispensation, you have only the judiciary and the executive existing. In a democratic dispensation, you have the 3 arms of government, the executive, judiciary, and the legislature. But in this case, because of a strike action, the judicial arm of government was temporarily cut off from governance. So for me, this is a danger lurking in wait for us. And it behoves on us as members of the Nigerian society to add our voice that, look, the National Assembly has a responsibility to do the needful. The judiciary has made the pronouncement in accordance with the rule of law that, no, Mr. President, you have overreached your powers. Your powers does not give you the right to override the Constitution. Whatever you do as the President of the Federal Republic of Nigeria must be in consonance with your oath to obey the Constitution at all times. So the Supreme Court has given its judgment on this, nagging matter. It is now the responsibility of the National Assembly to do the needful in amending that section of the Constitution to make, provisions for penalties. And also, like Liberals rightly said, there is a need for us to have the office of, a Minister for Justice. There should be a separation, a dichotomy, such that somebody will be out there who will be primarily constitutionally empowered to intervene on issues that affect justice for the society.
And of course, if we're going to have that office for Minister or even maybe Commissioner of Justice now separated from that of the Attorney General, it's still the lawmakers who would make that law. Absolutely. And the way I see it, if Nigerians don't actually bring pressure to bear on the National Assembly, I mean, these national lawmakers now, I don't think, I don't see the state legislature going to court at all. It means it will never happen. So we just wait and see. Very quickly, because we have to end. Yes.
Yes. You saw the way the National Assembly quickly amended the Electoral Act.
Because it affected them directly. Because it affected them directly.
So we also, this one affects us, like Mercy has said, this affects us directly. So let us also put pressure on them. Let them quickly also amend this that affects all of us.
You're absolutely right. Gentlemen, thank you very much for coming on the program, and thank you for your time.
Thank you for having me.
We'll take a short break now and we'll be right back. Stay with us. Don't go away.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the President of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.